Good morning, class.
Morning, sir.
Good morning,
Morning,
sir.
sir. Good morning,
All
sir.
right. So I'd like to welcome you to this morning's class, and we hope to look at the last two topics in this uh, particular section of the course content, and then we'll bring the session to a close. Today, we'll start by looking at briefing of cases and note taking. That's its starting point.
Sir, please, you are muted.
Hello, class. Hello, class.
Hello, sir.
Hello, sir. I can hear you.
Good morning, sir.
Hello, class. Can you hear me now?
Yes,
Yes,
sir.
sir.
Yes, sir.
Yes, sir.
Oh, sincere apologies. I ran into some technical issues this way. So sorry. All right, so we take it off from the beginning, which is briefing of cases and note taking. And by way of introduction, um, briefing of cases is one of the fundamental thing that we need to know how to do. And it's not just about reading a case, but one of the major reasons or the importance of case briefing is to test your understanding of the various subjects or topics that you have been treated, I mean, you have treated or you've been taught. And in this, it's more like an assessment of you. And consequently, it is a skill. Case briefing is a skill that you need to develop. Of course, it may be unfamiliar to some of you, but at the same time, you have to practice to, to master same. And in doing this, the first part is to read the case. Okay, to read the case, and I can suggest something like a first reading where you just do general scanning of the said case, and then that will give you the picture of what is before you. By the time you're going into the second reading, it will take you go into details, thinking about the entire case, how the judge arrived at the judgment, and so on and so forth. And in the process of doing all of this, you need to engage in analysis of what is actually going on. And then by the time you are done with that phase, you are able to understand what exactly is before you in order to carry out the exercise of case briefing. And of course, this also aids your technical, which will also aid further reading. And apart from further reading, is also enhancing your understanding of the subject, and it also gives room for linking the discoveries in the cases to what you have learned, and then to be able to know whether or not you are making progress or not. So the first thing we also now need to know is what is case briefing. As you can see on the slide, to brief a case or a case brief is a short summary of main points of the decision. Okay, you just want to brief it, you are having like a summary. Many a times when you see judgment of court, they can run into hundreds of pages. Just like yesterday, I remember when the judgment that brought in Comrade Adams Oshomole into power, when it was being delivered, the judgment, the reading of the judgment almost took a whole day. And the court had to find, So if you are to brief such a case, you probably will need 2 days or so. But in briefing, what you tend to achieve is to generate a summary of the main points. And by your training now, you already have understanding as to the fact that it is not every part of the judgment that will be of concern or relevant to you. But at the same time, providing a brief gives you what the gist of the case is all about. So case briefing is dissecting of a judicial, opinion, which is a case. You dissect the case, you look at the various parts that makes up the judgment, and so on and so forth. And it brings in the basis components of the judgment or the case. And with that, one is able to understand what the judgment or the decision is all about. So in reading the first paragraph, the second paragraph with the first, we understand that carrying out a case briefing is not rewriting the case on its own, and it's just to provide an executive summary of the key findings and the importance of the case. So that takes us to the second thing we want to look at, which is the importance of case briefing. Why do we have to engage on this exercise? So I'll say that besides being a good way to prepare for class or to have understanding of a case briefing presents a lot of other advantages, some of which are already before us this morning, and some that we don't itemize for want of time. So the importance include, number one, that case briefing helps you acquire the skills of case analysis and legal reasoning. In our last class, when we're talking about the topic legal analysis processes, we dealt with that extensively, and of course we saw what and what involved when a case is being analyzed. So case briefing helps to even practicalize all the skills that have been acquired under legal analysis and so on and so forth. And in doing that, you are able to reason alongside with the court, the reason why the court has presented the judgment, or what led to the determination of issues, application of rules, analysis of the various sorts and the judgment. So case briefing helps in acquire skills. Hello, class. Hello.
Hello, sir. We can hear you, sir.
Yeah, I just, can you see my slide?
No, sir.
No, sir. I cannot see anything.
No, sir.
I'm surprised.
No,
I
sir.
just lost connection again. Um, exactly. Okay. All right. I think it's the network issue. Let me try my internet source and see whether. Um, can you still hear me now?
Yes, sir. We can hear
Yes, sir, we
you.
can hear you.
Okay. What are the slide now?
Yes, sir. We have seen the slides already.
Okay. All right. So I said case briefing aids your memory. That is, it helps you to remember the cases and also help you to in writing or analyzing legal problems. And that's why when we are briefing a case, we are not advised to memorize or to cram the cases. But in reading it and applying the knowledge we have acquired in the various topics helps us to, learn to provide solution to legal problems. So, and through in all of this, you become better by the day. Another importance of case briefing is that it forces you to unpack the opinion and test your understanding of it by putting the fact and the analysis in your own words. Now, the fact that the court, a judge, has made pronunciation on a particular subject, it does not mean that you as an individual may not have a different opinion. And of course, that's why when cases go on appeal, the presiding justices or judges will also case briefing or understanding the content of a case. And when opinions are presented, there can be diverse of opinions. As a matter of fact, in a case where we have two judges or three judges sitting in a panel as a panel, both of them may have different understanding on the subject on ground because of their own analysis of the opinion. So case briefing gives you a daily means of assessing yourself because, of course, how do you test the knowledge that you are acquiring? It is through all of this. And again, it provides good brief provide useful study aids at the end of the semester. And what it does is that once you are, skillful in this aspect of case briefing, you are able to apply every bit of the judgment or of a case to the various topics that you have learned. especially the last set of topics we looked at, that's legal analysis processes. All of these helps in application of those subjects that we discussed. And then that takes us to the next subtopic, which is element of case briefing. Now we are delving into the case briefing itself and how we can do it, what you must do that we amount to case briefing. But I need to point out that there may be different ways or approaches in which you can deploy briefing your case. And the case in question will determine the kind of approach that you will also deploy. But irrespective of the various system or methods you've engaged in briefing the case, the following elements must reflect in your activities. And of course, that's because those are the key points that makes up the case or that makes up the entire case. So we're going to look at them one after the other. And the first one is the heading. The heading, which of course we talk about the case name, which helps in identifying the parties. And that's why most times when we are citing cases in court or to back up a legal argument, we mostly use the names of the parties. So you need to note, under the heading, you need to know the case title, you need to know the date, you need to know the court name, and even the date the decision was taken. Most times, the judgment of court will exhibit the date that the judgment was delivered. And all of these are important because you will need them when you are engaging those authorities in legal writing or legal arguments. That's why you can see cases like Jones versus Smith, Awoko and Fagbemi, and so on and so forth. But and again, when you want to make reference to rules or the principles of court that have been decided on in time past, we oftentimes refer to them as maybe the rules in Awoko and Fagbemi, the rule, Yomi and Ogundeson, and so on and so forth. And that's why it is important to have the heading, to identify the heading, because it also helps to distinguish a case from the other. Secondly, with the statement of facts. Yes, the last time we talked about, we had this class under legal analysis processes, we dealt extensively with facts. And that's what we also refer to here as statements of facts. So your fact section should aim to accomplish three things. Number one, it should make clear who the parties are. It will also provide a summary of the case. Because it is in understanding the facts that you also help to determine the issues and to determine whether or not the rule that has been applied or the laws, accord with the issues that have been raised by parties. And then, like we said earlier, it is important for you to understand, to know your facts. And because without that, like I said, it's difficult for you to understand other issues that pertains to the said case. And then you need to know how critical or important the fact is. And because the fact gives you or provide, adequate information that you will need to help in achieving the purpose of the case briefing. So, therefore, you need to your statement of fact when you are briefing it needs to make clear who the parties are. And again, you need to identify the key issues that the facts are pushing up, because it is in this that you will be able to properly assess whether the issues that have been raised by the parties are indeed correct, and that will also aid you in understanding the rule of law that has been applied to those facts. Okay, so the second part, like we mentioned, is a fact. That is the statement of fact. The third one is what we call, you need to identify the procedural history. Now, this is the fact. You need to know that sometimes a case that is before the Court of Appeal, for example, did not start from the Court of Appeal. Therefore, there is need to know, to have an history of how the case traveled up to the Court of Appeal. Meaning that you need to identify the lower court where the case was first decided. And you also need to decide whether it was decided by a trial court or an appellate court before reaching the particular court that wrote the judgment which you are reading. For example, if you have a matter in the High Court and then it was decided upon, parties were not satisfied, they move on to the Court of Appeal. The judgment that you may be reading may not be that of the Court of Appeal if the matter has gone ahead to the Supreme Court. So it is then therefore important to know the history, how it has moved, and what each of those courts decided, what the view, and even to the subject or the case. Apart from that, you also need to know the decision of each court. You need to know the damages that were awarded, if any. That is, again, if it is relevant to what you want to do as the person briefing the case. Then you also need to know who appealed the case and why the case was also appealed. So the procedural history is very important because it helps in stating or to understand the antecedent of the case. So that, again, if what you intend to do is doing a legal writing, you are able to provide a proper antecedent of the said case. Or if it is to answer a legal problem, you are able to put forward what the trial court said. You're also able to put forward what the appeal court said, even the various levels of appeal. You should be able to state what they said and the reason for their decision. All of these are what makes a proper history of the case very necessary. And of course, the grounds for the decision for the appeal will definitely be stated there, which most of the time form the focus of the court where the subject matter or where the case is being attended to. And then then we move to the next important element again, which is the issue. As we rightly discussed under the topic legal analysis process, the legal issue or the issue is the legal question or questions that the court is called to determine. And it is important that in case briefing, you identify the legal question, not just any other question, but the legal questions. And in doing this, you come across what we call substantive issues. We also come across what we also call procedural issues. So, it is, of course, on this issue that other activities of the court, are stake. So, like I said, we need to identify what the issues are. And like we said, that the issue or issues are the legal question which the court of law is called on to address. So I make mention of the fact that we have substantive issues, we have procedural issues. Under the substantive issue, we can also still divide the substantive issues to two. Number one is the point of law in dispute, because sometimes it may be the provision of the law that is in dispute, not even the facts. So, under substantive issues, you need to determine whether it's a point of law that is an issue or the key fact of the case relating to that point of law. These are the two major things that form the substantive issue under the case element number 4, which is the issue. Okay? Substantive issue, which I have said comprises mainly of the point of law in dispute and the key facts of the case relating to that point of law in dispute. That's one part. The second one is the procedural issue. Question then is that what is the party appealing, claiming that the lower court did wrong? Maybe the lower court did not follow the right procedure. It's also an issue. Maybe ruling relating to evidence, ruling relating to summary judgment, or ruling relating to tendering of evidence, issues that pertains to procedure, which the court is duty bound to take into cognizance. So sometimes a party may choose to appeal on any of these issues. And therefore, in your case briefing, you need to understand the issues. Sometimes it can be substantive, sometimes it can be procedural. And because we have said that the major role of the judge is to determine the issues of law that are, be presented to him. And then you need to be careful as to how you state the issue, meaning you have to be precise as much as possible in order not to make the entire case briefing exercise to be like rewriting the judgment itself or again or all over. So that's for element number 4. Element number 5 is the rule. Now, the rule, or which we also refer to as the rule of law, or the legal principle, is that this is the rule of law that the court apply to determine the substantive right of the parties. We've also discussed this one extensively. which can include the statute, case law, regulation, or other and similar materials or items. So the rule or legal principle may be expressly stated in the opinion, or it may be implied. Your purpose of briefing the case is to identify the rule. So you need to be sure that you also identify the correct rule. Because if you fail to identify the correct rule of law that was applied, it's very possible that you will miss the analysis and consequently the judgment. Of course, once you miss the rule, it will affect your reasoning as to how the court arrived at the judgment and what facts or what issue the court also consider in doing all of that. So the element number 5 is very key. The next one is the holding. Holding is what was the disposition. If the court issuing the opinion was a trial court, the result will usually be that the plaintiff either prove his case and won or failed to prove his case and lost. That is the holding. Okay, that the court will proceed whether the plaintiff did all he needed to do to prove his case and won or failed to do what he was supposed to do. That is to prove his case and lost the case. At the appellate level, the court can uphold or overturn the lower court ruling. Again, even the courts can uphold the holding, which again can mean the findings of the court. So all of these are the possibility, and when again more than one issue has been appealed against, the court will take time to provide or to look at the holdings, and then of course that's what again leads to further analysis before judgment is given. So basically, the holding as one of the elements of case briefing is to determine is the position of the court, having looked at the argument before it, where the court will say that the plaintiff has either proved his case and won or failed to prove the case and lost the case. Okay? The next element of case briefing is what we call analysis. Analysis. Of course, when the facts have been stated, the issues have been identified, the legal rule that controls the case have been determined, the judge has to apply the fact to the rule to arrive at a holding. And this is the body of the opinion, which we call legal analysis. And then we are talking about applying the facts to the rule. It's trying to apply what the law says to the facts that is in dispute. So that's why the court will not decide in vain or in vacuum. The court will oftentimes and usually rely on the position of the law or of the rule or of the statute or of a particular regulation. So this analysis, of course, is the process that takes into consideration the fact, the issue, the rule, and before the holding is what is arrived at. Another very important element is the judgment. This is the court final decision as to the right of the parties. The court responds to a party's request for relief. That's what we mean simply by judgment. The court in the lower court, if it is a trial court, we give the judgment. But if the case is on appeal, the appellate court may either affirm or reverse or give instruction as to what must be done. But the good thing about it is that you'll have seen reasons for the judgment, as in the ratio decidendi, as the case may be. Then another key element is concurrence or dissent judgment. Now we need to submit that because appeals are heard by panel of judges, which may be 3 to 7 as the case may be, or depending on the case or the subject matter. So what we are saying in essence is that not all judges on the panel will agree with the opinion that the majority has. So that means some of the judges may accept the whole thing, but not want to join the opinion. In this case, the disagreeing judge might write a separate concurrence. Okay, this is what the majority have said. This is what I feel. And that is also what is called a dissent. That's where you will hear dissenting judgment or dissent judgment as the case may be. And what that indicates is the fact that there are differences in the analysis that the parties or the judges must have looked at. Yeah, they are bound to reason in different way because justice is usually the focus. So, in your own analysis, your own case briefing, you need to identify why a particular judge is dissenting. And the court will always give reason. And that's why in such situation, it is the majority of those who probably will have about 7 justices, 4 have the same, they are in agreement, the same opinion and holding. The majority view will always succeed. But again, if such dissent judgment is revealed on appeal and the higher court feels otherwise or agrees with the dissent judgment, that may be what will be the judgment that the upper court may take, depending on the circumstances before the court. So, therefore, the dissenting judgment or view is the view of the minority in a particular case. And the other element is what we call definition of new vocabulary. If you don't understand some of the words used in the case, you need to make effort to consult reference books in order to be able to identify the new terms that have been engaged, and thereafter you'll be able to have a holistic brief of the case. Okay, so that is this is the lecture on briefing of cases and note taking. Of course, I expect that you put this into practice by looking at the subject that we've discussed in order to have a good grasp of what we are dealing with. Now, do we have any question on that before we take the last subject on this series? Any question? Okay. So, if we don't have question on that, but I hope you can hear me, or hope you can all hear me.
Yes, sir.
Okay. All right. So it's well understood. Okay. So let's move on to look at use of authorities in legal arguments and writing. Okay. Use of authorities in legal argument and writing. Of course, this is, usually very straightforward. And the question then is what are legal authorities? Legal authorities refer to sources of law or reference that support legal arguments. Legal argument. And this includes primary authorities, which are binding sources such as statutes, the provision of the Constitution, case law, and so on and so forth. Even in deciding a case, you also make reference to another case. This is part of what we are talking about when we are discussing the topic how to use legal authority in legal writing. So, aside the primary authorities, we also have the secondary authorities. Unlike the primary authorities that are binding, because the law is clear, is stated. The secondary authorities are of persuasive effect, and that's why we also refer to them as persuasive sources, such as textbooks, journal articles, legal dictionary, and expert commentaries. Of course, we've dealt extensively with this in our past lectures. So, what are the categories of legal authorities? We have the binding, which is the mandatory authorities. These are the ones that must be followed by the court. There is no room for shifting to the right or to the left. Example includes statutes enacted by the legislature. Just like when you take a section of the Constitution of the Federal Republic of Nigeria on a matter, it is the provision of the Constitution that will prevail because the law is clearly cut out and stated. Another one that is of binding authority include decision of higher court in the judicial hierarchy. Maybe decisions, judgment of the court of our court, which we have said is final, or which we know that is final by virtue of the authority that has been vested in the court by our laws. Okay, so that's that. Then it may use persuasive authority is another category, and this only influences the decision of the court, but are not binding. Like decision from foreign jurisdiction, obiter dicta from higher courts, even as well as academic writing. I did say when we were discussing reference books that by virtue of the years of studying and teaching a particular subject, a particular scholar can become an authority in this aspect. And I think we made mentions of the likes of learned scholars like Professor Andrew Smith, SCN. We talked about Professor Felix Fidelis Wadialo, and several of them. The courts usually consult this scholarly work, and then it helps them in doing justice. But of course, like we said, they are not binded by it, but they can influence because they explain the issues that are of concern in those tests. Maybe the issue of land ownership, how you can prove land ownership, and so on and so forth. Those legal authorities help in explaining them. Another thing we need to know under the use of authorities in legal argument, in writing or in legal argument, is the hierarchy of legal authorities. All authorities do not have equal powers. You cannot put the Constitution of the Federal Republic of Nigeria and put it side by side by an act that was made by virtue of the exercise of a particular section of the Constitution. So, usually when we're talking about the hierarchy, we see that the Constitution is at the topmost, and again, followed by the various acts of Parliament or laws made by the various houses of assembly. Then the judicial precedent, ratio decidendi can come in, and then subsidiary legislation is next, where we have the customary and Islamic law, where they are applicable to the subject matter. And then those persuasive sources, which we have, discussed earlier on. So this is the hierarchy. If the Constitution says something about a subject, the Constitution is superior to every other legislation that may speak to the same facts or that may be applicable to the subject matter. And then we look at the functions of legal authorities in legal writing. Why do we deploy them? For formality or for show? Okay, Babalola, you have a question? Please, you can unmute and ask.
Yeah, sir, you did mention in your former slide, if you can please go back to it, I will appreciate it, sir. Where you mentioned subsidiary under the judicial, are we saying that are we talking about the bylaws? Is that what we're talking about that, sir?
Okay, for example, by the virtue of the power vested in the legislature, for example, the UNILAG Act came into existence, which established the university and also gave the university powers to make statutes in the regulation of its affairs. The statutes made by the said UNILAG, empowered by the UNILAG Act, they are subsidiary legislation.
Okay.
Of course, that subsidiary legislation may be applicable to what a particular section of the Constitution is also applicable to. But in hierarchy, the Constitution will eventually, are you clear, sir?
Sir, again, sorry. Is it going to be right to now say that the delegated power of the ministers, can it be ascribed to this as well? Is it possible?
Can it be ascribed in what sense?
Okay. When we talk about administrative powers of the executive,
yes,
will it be right to say that this is under that as well?
Under subsidiary legislation, you mean?
Yes, sir.
Yes, it can come under it because it's the same act or that substantive law that establish that parastatal or that section of government.
All
So
right.
whatever it is that is put forward by it is requirement to subsidiary legislation or
Okay.
subsidiary rule or regulation as the case may be.
All right.
Are
Thank
you
you
okay
very,
now?
very, very okay, sir. Thank you,
All
sir.
right, thank you.
Yeah.
So let's move on. So why do we engage legal authorities in legal writing or legal arguments before the court? Number one is that they support legal argument. When you make a case for either the case before the court, the issue for determination is whether or not a valid notice has been issued to the tenant in a recovery of possession matter. And you are able to provide a legal authority that says that in all of it, once the tenant is aware that the matter is in court, that on his own, that is also a form of notice. So meaning that you cannot be in court for 5 years and you say because 6 month notice was not issued to you. If you are able to find authority that supports that, it makes your argument to go. The one I gave now, I'm asked us to use it in a similar case. I think in the case of Odutola and Paper Sack, that was where the court gave that judgment that they cannot complain that a particular notice was not given to you. But now you are aware that this matter is in court, that by virtue of the service of the originating processes on you, one way or the other creates notice. This one was not paid for 10 years. So once such a legal argument or authority is provided, it helps to support a particular argument. That's why it's very difficult for a lawyer to make a submission without looking at the relevant authority that backs it up. Just like saying that I have power to prevent a student from attending lectures. I will now go and you will now say no, except if the student has either is probably not well dressed for the particular class, or that the student is on the campus of the university illegally. So you have rules to say no. The rule says that every student will have right to attend lectures provided they have done XYZ. So that's one of it, the functions. Then demonstrate legal research skill. Of course, it should show. That's why sometimes when you are writing your answers in exam and you provide legal authority, it shows that you have done a thorough study of the subject matter. Then when we engage legal authorities in writing, it showcases familiarity with case law and statutes, and it also strengthens persuasiveness and professionalism. Okay? Eh? Another topic, subtopic under this is citing cases in legal writing. It is important that you must put in the case name, the year it was decided, and the citation, and at the same time the court. We have an example before us, which is the case of Aoko versus Fagbemi, decided in 1961. One, All Nigerian Law Report 400, and SC stands for Supreme Court. It's on cases CA, as Court of Appeal. So the citation helps the judges or the justice to also do their findings, because we are aware that somebody can cite a law that does not exist. That brings to remembrance a particular incident that happened where a law student was asked to write 10 Latin maxims, and then he has succeeded in writing. I was looking for one, and he just decided to put something up that looks like Latin maxim, like repese, repese, meaning what to be. Just say the meaning is what to be will be. If the lecturer fails to look at what the Latin maxim that has been provided, you may feel that is correct. After all, the lecturer is not expected to know all the Latin maxims in the world. So what we are saying under citing cases in legal writing is that you must be accurate and you must provide the parameters that are expected to either help the court or even the reader. Because sometimes when we are also reading articles and a particular legal authority is cited, we also go on to do further research. As a matter of fact, there are some other things that may be discovered in the said judgment that have been cited or said case that have been cited, and then one will be able to access it. Not that you provide a legal authority that is not traceable. Another thing you need to note is distinguish between ratio decidendi and obiter dictum or dicta, the case may be, so that you do not cite, even if you are citing an obiter, it also needs to be stated that the court is not misled in the performance of the duty that is before it, which is to do justice. Okay. Next is using statutory authorities. We need to cite with precision. That is the statute title, section, subsection, and paragraph. We have an example here clearly written, section 33, sub 1 of the Constitution of the Federal Republic of Nigeria as amended. So it has to be properly cited. The purpose of citing is so that the individual can refer to it. Like I said, it will be of make no sense if one is cited and the other party cannot verify. Another thing is techniques for using legal authorities. What are the techniques? Number one is to state the principle of law. Because for you to apply a legal authority, it must be something that supports your argument. It must be an argument, there must be an authority that supports your argument. Authorities are not cited for fun. You can't, you want to talk about maybe a subject issue relating to negligence, talking about Donoghue versus Stevenson. Then you are bringing Aoko and Fagbemi to support it. Of what relationship is the case of Aoko and Fagbemi, with case of negligence and so on and so forth. So you need to state the principle, then provide the legal authorities to support. Then support with relevant case law or statutes. Apply the authority to the facts of your argument and conclude logically. Everything must be done, in such an acceptable way. And of course, all of this still further emphasizes the importance of the facts of every case, which eventually leads to the issues, the analysis, and conclusion. And then before we close, we look at common pitfalls to avoid. Misquoting or misstating authorities. If you are writing to support legal arguments and you have cited a case that does not exist, and the court discover that, or even if it is not, even it may even be an error. And that's why we are encouraged in legal drafting to not to do it alone. Sometimes you need to have your colleague go through it for errors. So when you misquote, it may mislead the court. It can also lead to miscarriage of justice. Then rely on outdated or overruled cases is another pitfall that you need to avoid. You need to be able to ascertain whether the current position you hold is the current position on that subject. Then failing to analyze or apply authorities critically. You don't just push forward and then without creating the link between the issue or the subject matter and the said position that you try to advance. Okay, Charlie, you have a question? Please, can you go ahead? Good
Good morning,
morning.
sir. Okay, sir, please, I want to ask, are we supposed to quote the authorities verbatim, or can we rephrase what they say?
Yeah, depending on what you are doing. Sometimes you can paraphrase. Sometimes you may have to quote, depending on when you quote verbatim, you're able to quote verbatim to some extent, shows your what's it called? Shows that you know it, right? Apart from that you also of course, somebody who has quoted something verbatim and the one who paraphrased, they didn't do the same work, so they can't be rewarded alike. So whichever one you are able to do per time also determines the outcome you get. Okay? So
Thank you, sir.
you're welcome. In conclusion, a well-reasoned legal argument is only as strong as the authorities backing it. Most cases can be won by virtue of the authorities that have been provided. If the authorities are overwhelming to the point that it is clear to the blind, then the court will not find it difficult to find for the person who has provided sufficient authority. So mastery of identifying, analyzing, and properly citing legal authorities is indispensable to every aspiring legal practitioner or scholar. So that's one of the major reasons why you need to take this subject very important. So having said that, I'm going to open the chat box for you to put in your attendance. And again, please note that it's one name per device. So we're going to take Daniel, who is asking a question. So please, you can send in your attendance right away. Daniel, you have a question?
So, good afternoon, sir.
Good afternoon.
So, sir, I was going to, please, can you take us back to? I was going to ask you to give us, if you could please help us with an example of how you cite the case practically. You already gave us a list on how we'll do it, but maybe for example, if it is a situation or a case of negligence, and the principle is about the modern day negligence, which states that okay, you don't exactly have to your neighbor does not exactly have to be the person next to you. Anybody can be your neighbor.
You are trying to be a lazy student. You have been given all you need to achieve that. You can't spoon feed you. Based on what we have done, go and carry out your research. You will be able to achieve it. All right, so in the absence of other questions, we call it a day here. And that's the end of my lecture for the semester. Mrs. Adede Yadeyemi will be coming forth to take the remaining parts of the course content for the semester. But yeah, we make arrangement with your coordinator before the exams. We're going to have a class, a physical class, where we're going to discuss some things that may interest you regarding the various topics that we have discussed. Okay, so having said that, I want to thank you for your cooperation ever since I took over the section of the course content. And thank you for the participation. And thank you for the lecture of today. Enjoy the rest of your day. God bless you.
Thank you, sir.
Thank you, sir. Thank you so much, sir.
Thank you, sir.
Thank you, sir.
Thank you, sir.